Okay, great. Okay, good morning, everyone. So I'm going to speak very quickly, I think, on two areas. One is copyright law and one is data protection law. And I guess my caveat at the beginning is clearly these laws are somewhat different across Europe. Clearly, in terms of European Union law, there is some level of harmonization. So I'll have to speak at a level of generality, and I think I'll be probably more accurate in terms of these Bulgarian bodies of law rather than Serbian. So first of all, let's talk about copyright. And I think in both these topics, data protection and copyright, my general advice would be you probably cannot avoid copyright in what you are doing, because you're going to be talking to people are going to be contributing. We heard from Thomas about photographs. Copyright is going to be difficult to avoid. And then my advice, because of the complexity of data protection law, is if at all possible, avoid data protection, i.e. avoid using people's personal data. If you're involved at Thomas's in a library in a university, the university will have a data protection officer, an expert. And if that relationship is university to citizens, then you should definitely engage at the start of the project with the data protection officer. And I suppose my general advice for both these bodies of law is, before you start the project, think the copyright implications and think of the data protection implications. Data protection, again, reiterating, relates to information regarding, in most European countries, living people. Some countries have a few extra years on top of that, but any information that allows you to identify a living person then attracts data protection laws. So copyright is sort of a balance. It's not a beautiful balance like this beautiful picture, yin and yang, but it is a balance between protection and access. And the reason that I can talk generally about this is because there is some level of harmonization globally through international copyright treaties overseen by the World Intellectual Property Organization. Across the European Union, there is, as I said, certain levels of harmonization that we see from copyright directives. And again, in data protection, we see a regulation which should create even more harmonization than a directive. And then obviously we have Serbian copyright law, Bulgarian copyright law, Serbian data protection law, and Serbian Bulgarian copyright law. So copyright is essentially the fixation of an original creation, something creative, and once that's fixed in a form, in a sound recording, in a photograph, in some text, in a film, etc., then copyright essentially kicks in. And it involves human beings. So this poor little monkey isn't going to get copyright for his nice little painting there. It's sort of divided up into what we've already discussed, different kinds of work. This is the way in the UK that we divide things up into text, and that could be a sound recording as well. My words. So essentially words, really, words fixed in some format, sound recording in a word processing document on a bit of paper. We have dramatic works, we have artistic works, photographs, we have music, broadcast, sound recordings. Essentially anything you can imagine fixed attracts copyright. Copyright doesn't have to be registered. It kicks in as soon as the work is fixed in some format. Doesn't have to be registered. It's got to be original, i.e. it's not a copy of something else. And in the European Union and the UK, of course, also we have the concept of database rights. So data, whatever data might be, what I call pure data, let's think of a number, or just basic data. So thinking about natural science, citizen science, if you're involved with people collecting information about what birds they're seeing in their garden, for example, people might say 5 blackbirds, 1 falcon, 3 finches. That sort of level of information isn't creative; it's factual, and therefore there isn't any copyright. But in the EU and other countries, but it's mainly a European concept, you actually have a right, which is a database right, where the actual labor and time involved in collecting data, the obtaining of the data, the verification, the checking of that data, and then the presentation also creates a database right. So taking Thomas's example of Pearl Harbor, in that instance, if people are contributing photographs, then that photograph is probably still in copyright. It will be in the UK from that period in most instances. So again, you need to check how long the copyright might last for. If people are contributing data, you have to ask the question, well, who is obtaining that data, collecting it, who's checking it, who's presenting it in a database? Because like it or not, that will create a database right. So in these projects, you've always got to think again at the beginning, what rights are being created, how do we get permission to use those rights that they're creating, and how do we want people to use the outputs of the project? Because the outputs of the project are almost certainly going to have copyright in them, and they're almost certainly going to have database rights if you're dealing with the collection of data. So again, in all these projects, you've got to really think through, is there copyright, is there database at the beginning, and how do we actually allow license the reuse of the information that we're producing? In the EU, and I'm pretty sure in Serbia as well, copyright lasts for life plus 70 years, and database rights last for 15 years. But any amendment to the database kind of creates a rolling 15 years. Something switch that microphone on. The owner is usually the author, so certainly in a citizen science project, it's probably going to be all the people that are creating the information, supplying the data. Maybe if they're an employee of a university, then maybe the copyright sits with the person, or maybe it sits with the university. That's, in the interest of time, I'm zooming forward. So essentially, copyright creates a monopoly, and that monopoly actually, during the period of copyright or database rights, there are what are called exceptions. So exceptions to that monopoly right. And the common ones are copying for personal purposes. So that might be for personal enjoyment, or it might be for non-commercial research purposes. So you can make copies for your own personal use, but usually there are limits on how much you can copy, because obviously if you can copy the whole thing, then the question becomes, well, why aren't you licensing that whole thing or buying that whole thing? There are usually exceptions for teaching, and then there are exceptions for quoting. So there are, during that monopoly period, kind of these exceptions that you could use for personal purposes or quoting, but generally the instances where you can copy wholesale somebody else's work are rather limited. So, as I said, everything you create is probably going to have copyright or a database right in such a project. You've got to think about this at the start of the project. You've got to think, how do I get permission to use all this stuff? And then I've got all this great data, or I've got all these great photographs. How do I then share them? Well, I can't share them unless I've got the permission to begin with. And then it's got to be clear the terms and conditions under which I share them. So you may or may not have heard of Creative Commons licenses. If not, I would definitely look at them in the context of these projects. They're very simple licenses, which also are computer readable. They're very simple, and there are 6 of them with different kind of levels of complexity, ranging from CC BY, which is you can do anything with this data, with this information, as long as you say that it came from me. And then at the most complex end, you have attribution. You've got to say it's from this person. Can't use it for commercial purposes, and you can't create derived works. So you can't create anything from that original work. So that's copyright in 10 minutes, if not less. Data protection law is very complicated, and I think I will go through this very, very quickly. So personal data relates to any information relating to an identifiable living person. There's a category called sensitive personal data, which brings with it different sorts of obligations. You have a concept of a data controller. So the person, the body, the organization that decides how and why you're using this personal information. And if you're a data controller, the law brings with it many different obligations, which we won't have the time to go into. So the important thing is to establish, if you're using personal data in the context of a citizen science project, somebody will be the data controller. Somebody, some people, some institution will decide the purpose and the manner for which that data is used, and that will bring with it a raft of obligations in the law. So first of all, in order to use personal data, you've got to have a legal basis to use it. So here are the 6 grounds in the General Data Protection Regulation, the GDPR, that allows you to use personal data, and you must have one of these grounds. So that could be contractual, permission, it could be a legal obligation to do something, or number 6 is, this balance of interest test where it doesn't harm, it's in the interests of the data controller, and it doesn't harm the interests of the people whose personal data it is. So you've got to have a legal basis to use personal data. Again, we talked about obligations. You've got to ensure that use of personal data is lawful. See previous slide. You only use the data for the purpose for which it was collected. You can't collect it for purpose A and then use it for purpose B. You don't collect more personal data than you really need. It should be you've got an obligation that the personal data is accurate and kept up to date. Don't keep it forever. Keep it as long as you need it for the project. Got to be secure. And the data controller, the person that's deciding all this, is ultimately accountable to the people whose personal data it is, as well as the kind of the national organization who oversees data protection law. All I shall say is, if your personal data is being used, you have rights to find out, in most instances, various things about your personal data. There are exemptions to not everything. It doesn't mean you can do what you want, but there are exemptions to certain obligations that data controllers have for scientific research. So for research, let's say. So there are some things obligations that you won't have. But as I said at the beginning, I would, if you're using personal data, if you have to, I would avoid it. You probably can't because you're dealing with emails, for example. But if in a university context you're using personal data, I would start at the beginning of the project and go and talk to your data protection officer. So that's a very quick run through of copyright law and data protection law.